Good morning.
Good morning, Your Honor.
Mr. Hines, I believe you filed a motion today. Come forward.
Your Honor, Jason Methvin, standing in for City Attorney Cloyd Benjamin.
All right. Mr. Hines, you have filed a motion to demand for court-appointed attorney. Is that right?
Yes, sir.
Okay.
Yes, Your Honor.
You can proceed. It's your motion.
I stand on the motion. I understand that the federal poverty guideline is less than $12,880 is the standard, and I fall below that. That's all I have to add.
Well, Mr. Methvin,
Your Honor, my understanding is that in cases like this, that he's got to have a showing or the court's got to make a finding of whether or not Mr. Hines is, in fact, indigent. I've not seen any evidence that's going to substantiate the fact that he does qualify for an attorney, and that he cannot hire his own, number one. Number two, Your Honor, I also have number two, Your Honor, Mr. Hines was arraigned when?
February March 7th. I'm sorry.
I'm not so sure whether or not he would qualify for appointment in the first place, but, Judge, I'm not going to assume one way or the other that they are or not. I would have to defer to them as to whether or not they want to do that. I think that, from the state's perspective, Your Honor, given, I think, the nature of the charge that he has, which is resisting arrest by giving false information. Having been a public defender for 13 years, I don't think there's a lot of trial preparation that would be required. We would simply ask that the trial date be maintained. We don't want it to be continued. Mr. Hines needs to have his day in court certainly, but he does not need to postpone it indefinitely. If the court believes that he qualifies for the appointment of counsel, that's up to the court, but I think he needs to have his trial date on Monday.
Mr. Hines, your motion referred to several code articles, and then the revised statute 15-141. And that's significant, because what this means is it's not just on me to, say, enforce the Indigent Defender Board to provide you an attorney. They have the right, under that lengthy statute, to determine on their policies, on their guidelines, on their manpower, whether or not to handle your case. So I can't order them to do it, but I can strongly suggest you contact them. I guess my first question is, have you made the effort to contact them?
Yes, sir.
Okay, and have you spoken with them?
Yes, sir.
Okay. Did they take an application from you?
I took an application from them.
I mean, did you complete an application with them? Did they tell you whether you qualify or not?
No, sir.
Okay, because that's their purview to be able to whether or not they can represent you, whether or not you qualify financially, whether you qualify under their guidelines as to whether or not they feel that this case is worthy of their representation. And I don't say that insultingly, but they have more clients than they have attorneys. And so they do have to have some discretion as to what they take and what they don't take. They usually don't represent misdemeanors. That's my understanding. As Mr. Methvin said, they usually represent people who are in graduated offenses where each time someone is subsequently charged with an offense, it is progressive in nature and the punishment is higher. And the other matter is, they handle mandatory incarceration cases. In your case, the potential punishment is 0 to 6 months, so it's not mandatory that you would be incarcerated. But anyway, what I'm going to do today is I'm going to order you to go directly to the public defender's office. I know you're aware of their address, because it was on your summons when you were first given a court date, but you are aware of their office, correct?
Yes, sir. I've been there 2 times, and they were closed. Their hours seem very limited.
Well, I'm going to contact them and make sure they accept your application right now and talk to you.
Alice told me she would be there from 8:30 to 12 o'clock.
Okay.
And then,
Your Honor, I think that he has said, in fact, that he turned in an application.
He just took one, I think. That's what he did. He didn't.
Did you fill it, did you?
He didn't fill it out.
I have an application. I didn't. It's trash. I'd like to add, though, this arrest isn't about false information.
Right.
Just want to get that.
It's actually not providing information. Correct.
Yes, sir. I had the application and it's not in good shape.
Okay. Well, they will give you a new one. But again, they will do it on the spot with you, is what we're saying. Alice Martin is the intake person, and she will do your application. And if they're there this morning, I will call to make sure they will see you this morning. Now, that doesn't mean they will take your case, but you need to go through that process and have it completed. So as of now, I will keep your trial date on Monday, the 11th. If for some reason you contact them, and they decide they need to be involved, and they want more time, then they can file a motion for a continuance, and the state will have a response to that. But I can't order them to take your case. But I can tell you, you need to go there right now, today, and go straight there and complete your application. I mean, that's the hitch in the process. The problem is, you haven't applied with them. It isn't that anyone's keeping you from seeing them. You haven't completed your application with them. So your motion intimates the idea that we're not allowing you to have an attorney. That attorney's office is there. You have to make the effort to go there and apply and complete your application and see what they're going to do.
Yes, Your Honor. I was under the impression that I could go do it in there's alternative ways through the court or through them.
No, there's one way.
Okay.
There is one way. I cannot appoint. I can suggest that they contact you, but they have their own. That's what that whole 15941 statute is. It's a whole setup where they decide their plan and how their organization is set up. And you referenced it in your motion, so I'm sure you reviewed it. But that is how they decide what they're going to take and what they're not going to take. There are far more people who are in a position to need an attorney than there are attorneys in the state. So as a result, they did not take every case that comes in. They don't. I know that for a fact, because they've sat in here before and not taken every case. That would mean they would take every traffic case, every speeding ticket, everything like that. They don't do that. So it's up to them. They set their own guidelines to who they're going to represent.
Yes, Your Honor. We have a right to representation,
But again, so then I ask you, do you think you have a right to representation if you have a speeding ticket?
Okay, for minor, it depends on the level of severity.
That's what we're saying.
Okay,
That's the whole point. They have the discretion to determine what they have the manpower to handle. I'm not speaking for them. I'm just telling you there is their process. But the idea that every single person who ever violates the law is entitled to an attorney is incorrect. Because then, again, you jaywalk. Do you have an attorney? If you have a speeding ticket, if you run a stop sign, should you have an attorney appointed for you? Those are all violations of the law, right? Technically, they're crimes. And so would you have someone appointed for that? No, you yourself said, no, you wouldn't, because they're minor. Well, they may consider this minor. I don't know. That's their decision. That's what the law you quoted says. They get to have the discretion to who they will represent.
and jail time is a big hump for the severity level on.
Usually, it is for them. I mean, again, that's their discretion and their guidelines, not mine.
Your Honor, I think that, just to add to what the court is saying, if this were a charge of resisting an arrest by force or a battery on a police officer, those, in fact, have mandatory incarceration times, and I do know that the public defender's office would appoint, because, under those circumstances, I believe the U.S. Constitution mandates such an appointment for a case where you will necessarily have to go to jail.
Right.
I don't think that this is the case.
That's correct. Well, again, that's not my decision. I'm not telling you that you can't have an attorney. I'm telling you that you have to go apply and find out if you can get one. But you have to do it, and you probably should have by now. But since you've already seen them and gotten an application, but that's on you. You have to go do that. So it's not you're not waiting for the court to go see if you can get a public defender. You need to go see if you can get a public defender.
Yes, Your Honor. Should I wait until after the call is made?
No, you should go right now.
Oh, yes, sir.
They're open, or at least Alice is going to be there this morning. So if it's Alice Martin, and when you go there, you can ask to speak with her, and you can apply. I have no idea. I have not applied for services there, so I don't know the process, but I can tell you they have their discretion of who they represent and who they don't.
Yes, Your Honor.
Okay. So I will go ahead, and I'm not going to dismiss your order because you're asking for something I don't control. But what I will do is tell you, if you go right now and contact them, they should be able to answer your question. The next step is if they do accept, you need to contact us and say they're going to represent you, or, actually, they need to contact us and say they're going to represent you so that we'll know. ND, if they or any other attorney you may seek to have desires a continuance, you need to contact both myself and the district attorney's office if you plan on asking for a continuance.
Yes, Your Honor.